Okay, good afternoon. Today we're going to continue our discussion on the preliminary considerations. Now we're going to discuss first the categories of employees. Now there are three classifications of employees under the labor code. First is the managerial employee. Second is the supervisory employees and the rank and file employees. When you say managerial employees, those are employees who are vested with powers or prerogatives to lay down and execute management policies and or hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. So in other words, for those employees who has the power, so even though it is not we are not depending on the position or the nomenclature or the name of the position. So for example, if that particular position is called an accounting in charge, however, that particular person has the power or prerogative to hire, suspend, recall, or discharge a particular employee under him, is also already considered as a managerial employee. Okay, again, managerial employees are those vested with powers or prerogatives to lay down and execute management policies and or hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. Okay, example, if your superior has the power to discipline you in violation of a company rule, then that particular person is or belongs to managerial employee. Now, the supervisory employees are those who, in the interest of the employer, can effectively recommend managerial actions such as laying down and execution of management policies or the hiring, transfer, suspension, layoff, recall, discharge, assignment, or discipline employees. So the key word here is recommend. So if that particular employee has the power to recommend for a certain employee to be dismissed or to be transferred or to suspend, though not the implementer or the enforcer, but only recommends, then that particular employee is considered supervisor or belongs to supervisory employee category. Then the last one is the rank and file employees. These employees are those who are neither managerial nor supervisory. They can either be daily paid or monthly paid. So when you say daily paid, are those who are paid only the days they actually work and on unworked regular holidays. So in other words, they are paid by the days of work. So if they don't work on that particular day, then they are not paid. So those are daily paid employees. Then we also have what we call monthly paid employees, those who are paid every day of the month, including unworked rest days, special holidays, and regular holidays. So in other words, they are paid 365 days in a week, in a year. Okay? So for example, in a month there are 30 days, but employees actually work for 5 days a week. So those Saturday and Sundays, assuming that the employee is required to work Mondays to Fridays, and they have day off during Saturdays and Sundays, but if they are monthly paid, even they are not working from Saturdays and Sundays, they are still paid during those days off because they are monthly paid. Okay? What is the significance of the classification? So why do we need to know if that particular employee is a managerial employee or supervisory and rank and file? So what's the significance? The purpose of determining eligibility to form, join, or assist in the formation of a union and the degree of their culpability in disciplinary cases. So that's one reason why we need to determine the type of employee. If they are eligible or not to form or join a union, and of course the degree of culpability or liability in disciplinary cases. So managerial employees are not eligible to form or join or assist in the formation of a union. So they are prohibited to form, join, or assist in the formation of a union. Supervisory employees can form, join, or assist in the formation of their own labor union. In other words, they can form union uh, where members are all supervisors. So they can join, form, or assist for uh, their particular union, which members are all supervisory or supervisors, but they are not eligible for membership in the rank and file union. So they cannot join or assist labor unions or those union for rank and file employees, but they can form on their own, wherein members are all supervisory employees. So what is the significance of the classification on the degree of culpability? So the first one is pertains to the formation, the terms of joining or creating a union. Okay, for this one is the degree of culpability or liability. Okay, so for managerial and supervisory employees are subject to stricter norm of discipline than rank and file employees, of course, because they belong to higher level of employment. Okay, so managerial and supervisory employees may be dismissed by the mere existence of a basis for believing that such employee has breached the trust of his employer. So in other words, for managerial and supervisories, they can actually be dismissed if the employer already or, or doesn't trust them anymore, or they committed something that breached the trust of their employer. For example, if a sales manager has committed or probably mm, committed a violation in terms of the process on selling the products which the employer did not require. So with that particular offense, the salesman already breached the trust of his or her employer. Okay. Another example could be negligence on their work. That could also be considered as a breach of trust, or anything a particular manager or supervisor did not perform on what the employer expected of him or her to do. Okay, so breach the trust. However, for the rank and file employee, proof of involvement in the question act is required. Mere uncorroborated assertions and accusations by the employer will not suffice. This means that in case a rank and file employee commits a violation, the employer has the burden of proof to prove that the employee committed such offense. Therefore, if you're the employer, through your HR representatives, the HR representative must secure all the evidences, the documentary evidences to prove that the employee really committed such grave offense. Okay? Why grave offense? Especially if it requires termination or the result of the procedure will result to termination, then a valid cause must be present. Okay? Now, we'll discuss those things further on our later topics, okay? Now, let's go to the statutory classification of employment. So, there are three categories of employment. One is regular employment, second is non-regular employment, and third is casual employment. So, let's discuss this one by one. What is the significance of the categories of employment? Why do we need to determine the type or category of employment? It is because of the provision on security of tenure under Article 294 of the Labor Code. So in cases of regular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by this title. Okay? So in other words, you cannot terminate a certain type or category of employee or employment if you does not have a just or valid cause or authorized cause for that particular employee to be terminated. So it depends on the classification. If the classification is regular, so it should be dealt with strictly and you should be serious or prepared on whatever proof that you should have in order to terminate. So you cannot terminate right there and then a particular employee, especially those permanent or regular employees. Okay. So for purposes of determining the tenure of employment, so for regular, they are entitled to security of tenure, hence they cannot be dismissed without valid cause. Okay? So in relation to the regular employment, which has tenure, they are not easily be dismissed without valid cause. For non-regular, they are also entitled to security of tenure, but in a qualified manner in the sense that they cannot be dismissed without valid cause during the term of their employment. For example, if their contract is for 1 year, they could not be terminated within the year. Okay? Then lastly is casual, who have rendered at least a year of service, is entitled to security of tenure. Their employment cannot be terminated without valid or authorized cause as long as the activity in which they were engaged exists. Okay, so rendered at least 1 year of service. Okay, so there should be an authorized and valid cause even you are a casual employee, as long as the activity in which they were engaged exists. So if they are hired for 9 months, so they cannot be terminated without valid or authorized cause since the activity is for 9 months, or it should be completed within 9 months. So if it is not yet completed, then you cannot terminate or dismiss without valid or authorized cause. Now, for probationary employees under Article 296, they are also entitled to security of tenure in the sense that they can only be dismissed for a valid cause or for failure to comply or to qualify for regular employment. Again, probationary employees can be dismissed for a valid cause or for failure to qualify for regular employment. Under the regular employment, under Article 295, this is, or what are those considered regular employment? You are a regular employee or belongs to regular employment classification if you are performing a job or if the employee is engaged to perform activities necessary or desirable in the usual business or trade of the employer. So the key words there are necessary or desirable in the usual business or trade of the employer. So as whether the employment is regular is determined neither by the employment contract nor the name given to it by the employer, but the nature of the job. Again, the determinant is the nature of the job. If it is necessary or desirable, then that is irregular employment. Repeated and continuous rehiring is also an indication that the activity is usually necessary or desirable in the usual business or trade of the employer. So for example, if you hire a scanner, that's for 5 months for example, and then you just terminate the employment of that scanner after 5 months, since the contract there provided that the particular employee will be hired for 5 months. However, after a month, you rehired that same employee and of course same position as a scanner. So again, the employee rendered another 5 months. So that employee, because of the repeated hiring and continuous rehiring, can be considered as a regular employee. Non-regular employment. It is a job where the employee was engaged for a specific duration or for an activity that is not usually necessary or desirable to the business or trade. It may be classified into the following: project employment, seasonal employment, fixed-term employment, probationary employment, and casual employment. Now let's discuss this one by one. When you say project employment, this is a job where the employee was engaged for a specific undertaking, the completion or termination of which has been determined at the time of the engagement, regardless of the number of years that it would take to finish the undertaking. So in other words, as long as the project exists, it doesn't require a particular years or number or length of service. So length of service is not the controlling determinant of project employment. It is the project itself. As long as the project is still unfinished and is still ongoing, then there's still employment for those project employees. Okay? So when the project ceases or the project is completed, then the employee can be terminated since the project is already completed or ended. Now, the tenure of a project employee is coterminous with the work to which the employee was assigned. So in other words, actually, in other words, the employment of a project employee depends on the work itself or the project itself. So as long as the project still exists, then the project employee will still continue to work, okay, and cannot be easily dismissed. So once the project or any phase thereof for which the employee was engaged is completed, the employment terminates. So in other words, if you are hired as a project employee on a face-to-face basis, like for example, in a 5-story building, and you are hired for the painting of the facility. So if you are a painter and you are considered as a project employee on a face project category, wherein you work through the phases of or the completion of the painting job. Okay, now once the whole building is done with the painting jobs, then the end or the project employee ends such service or employment, because the phase of his project is only under the painting process or the phase. Okay? So it doesn't necessarily mean that a project employee is coterminous with the work of the whole building itself. But again, it depends on the project of wherein such employee is being hired. Okay? Now, once the project is ended or terminated, a report of termination of employment should be submitted to the nearest public employment office or to the DOLE, Department of Labor and Employment, and the fact of termination of project employees. So, the names of those project employees should be submitted to the Public Employment Office or to the DOLE or Department of Labor and Employment. Failure to report is an indication that the job is not project employment but regular employment. So it is very important for the report to be submitted to the Department of Labor and Employment. Project employment or employees, once project is completed, are not entitled to separation pay. So again, project employees whose employment is terminated by reason of completion of project or phase thereof are not entitled to separation pay. So they are not entitled to separation pay. However, there are companies who are generous enough to give separation pay. But again, that is not mandatory but discretionary in terms of the employer. Another is seasonal employment, or another type of non-regular employment is seasonal employment. Seasonal employment is a job where the employee was engaged to work during a particular season. The tenure of employment of a seasonal employment is coterminous with the duration of the season. If the same employees are repeatedly engaged every season, they become regular seasonal employees, in which case they cannot be terminated without just cause. During off-season, the employment of these regular seasonal employees is not severed but merely suspended. Now, example of a seasonal employment are those workers or employees who are hired by example supermarkets during Christmas seasons, because during Christmas seasons there are a lot of customers, so they hire seasonal employees to help the manpower needs of a particular supermarket or department store. Okay, and of course, once the season or the Christmas is or ended, then that seasonal employee's employment will also be ended or terminated because their employment is coterminous with the duration of the season. Okay? However, if that same persons or employees are being hired by the same employer on the next season, example Christmas 2020, and then again they are hired on Christmas 2021, now they are considered regular seasonal employees and they cannot be terminated without just cause, and when Christmas 2022 comes, they will be again employed or be contacted to work again during Christmas season because they are already regular seasonal employees. They are not, the end of the season will not sever their employment but merely suspended. However, before or after the Christmas season, they are not paid. However, they are expected to be contacted by the employer once the Christmas season comes again, since they are, again, regular seasonal employees. Now, for fixed-term employment, these are parties by free choice have assigned a specific date of termination. Okay. So again, both parties, by their free choice, came to a specific date or assigned a specific date of termination. The fixed-term employment is only valid when knowingly and voluntarily agreed by the parties without any force, duress, or improper pressure upon the employee, or it satisfactorily appears that the employer and employee dealt with each other on more or less equal terms with no moral dominance. So in other words, as long as they agreed voluntarily without any force, influence, duress, or improper pressure, and they are on equal footing or equal terms. So those are two requirements for fixed term employment. Another classification or types of non-regular employment is casual employment. It is a job where the activities performed by the employee are not usually necessary or desirable in the usual business or trade of the employer. So, on regular status, a casual employee who has rendered at least a year or at least 1 year of service, whether such service is continuous or broken, is considered as regular employee with respect to the activity in which he is employed. So the significance is the casual employee or employment cannot be terminated without valid cause while such activity exists. The regular status attaches to the casual employee on the day immediately after the end of the first year of service. So when you hire a casual employment or employee, once it exceeds 1 year in service, that employee is now considered regular employee. So always remember that when you hire a casual or contractual employee, it should be less than a year. Okay? Otherwise, even an excess of 1 day, that casual employee or contractual employee is already acquires a regular status of employment. So the meaning of at least 1 year of service, it means service within 12 months, whether continuous or broken. So reckon from the date the employee started working, including authorized absences and paid regular holidays, unless the working days in the establishment is less than 12 months as a matter of practice or as provided in the employment contract, in which case the said period shall be considered as 1 year. So regularly, 1 year is considered 12 months. However, there are some companies that only works for 10 or 11 months and considered it as a year, but again, based on their practice. So it depends actually on the company, but again, as standards, 1 year is equivalent to 12 months. Now, for probationary employment, it is a job where the employee, upon his engagement, is made to undergo a trial period to enable the employer to determine his fitness for regular employment on the basis of reasonable standards made known to him at the time of engagement. The basic requirements for hiring probationary employee are the following. Number 1 is written contract of probationary employment. So in other words, as a probationary employment, you should have a specific probationary contract of employment. Notifications of standards for regularization. This includes employer apprises the employee that he will be subjected to performance evaluation after his hiring, or employee was given reasonable time and opportunity to be made fully aware of what is expected of him during the early phases of the probationary period. The first one, when you hire a probationary employee, the employee should be you should inform, or the employee should be aware that he or she will be subjected to performance evaluation, depending on the policy of the company. So if a certain company only have one evaluation, probably before the end of 6 months, or other companies, they have two evaluations, probably an example scheduled on a 3rd month and on the 5th month during probationary period. So again, inform the probationary employee that he or she will be subjected to performance evaluation during his or her probationary employment. Secondly, in order to comply the notification of standards for regularization as a requirement for hiring a probationary employee is the employee must be given reasonable time and opportunity to be made fully aware of what is expected of him during the early phases of the probationary period. In other words, the employee should be trained on what are the company's expectations and should be given an opportunity for the employee to perform his best in accordance with the company's standards. Now, the duration of probationary employment is 6 months for ordinary employees. Computation is reckoned from the date of appointment up to the same calendar day of the 6th following month. So, in the contract of employment or the probationary contract of employment, the duration should be written in the contract. That's from the date hired until the end of probationary. So, it should be written in the probationary employment contract. So, under Article 13 of the Civil Code, probationary period of 6 months consists of 180 days. Okay. So, 180 days because 1 month is equivalent to 30 days times 6, that is 180 days. Now, second duration of probationary employment for those teaching and academic non-teaching personnel as provided under the Dole-Dexted Test the Order Number 1. For those teaching personnels under the elementary and secondary level, the probationary period is 3 consecutive school years. Secondly, for tertiary and graduate levels, 6 consecutive semesters, and tertiary level or trimester basis will be 9 consecutive trimesters. Please take note that part-time teaching or academic personnel are not eligible for regular or permanent employment even if they have satisfactorily completed the required number of years or trimesters of probationary employment. Now, as we've learned, the duration of ordinary employees for probationary employment is 6 months. Now, my question is, can it be extended? Yes, it can be extended to give the employee a chance to improve. However, this is already an exception. Okay? Exception to the general rule. The general rule is 6 months or 180 days. But if the employer or the employee asks for a chance to improve, then it could be, the probationary employment could be extended. However, it should be done on or before the expiration of probationary period. Otherwise, the employee will be automatically become a regular employee by operation of law. This means that if in case you are going to extend the probationary contract or the probationary employment of a probationary employee, it should be done before the end or before the expiration of the probationary period. For example, if the probationary employment ends on September 1, then the extension should be agreed before September 1 or could be August 1, 30 days to be safe before the expiration of probationary period or during the 5th month, not after the expiration of 6 months, because an extension of 1 day is the employee will be deemed regular. Okay? So Article 296 of the Labor Code is clear. An employee who is allowed to work after a probationary period shall be considered a regular employee. Okay? Now, again, for an example of this, for example, if a manager asks the HR that he is going to extend the probationary contract of the employee and the employment contract ends on that day, then as an HR, what are you going to do? Are you going to allow the manager to extend the probationary employment or not? Of course, you will not allow. So you tell that manager that it is not allowed according to the labor code, because if you extend the probationary employment after the expiration of the probationary period, that employee is now considered a regular employee. Okay? Now, knowing these provisions or the knowledge of the labor code again is very important. Why? Because in an HR, especially if you will become an HR manager later on, you need to know the law, because all those other managers, example production manager and other department manager, doesn't know or doesn't have knowledge about the labor code. So as HR manager, it is a plus or it is a requirement for you to really know the law. Otherwise, you will face a lot of lawsuits, cases, and of course, HR manager will be part of the respondents if there will be cases filed against the company. Okay, so again, as an HR student, you should be knowledgeable on the labor law and how it will be implemented or applied to your work, to your workplaces. Okay? Now, termination of probationary employee. So, you can only terminate a probationary employee for the following reasons. One is for any of the valid or authorized causes, which will be discussed on a later period. And then secondly is for failure to qualify as a regular employee in accordance with reasonable standard made known by the employer at the time of his engagement. Now, before during the orientation of a probationary employee, all the standards required by the employer should be discussed to the probationary employee. So whatever the criteria of evaluation should be discussed to the employee for the employee to learn or know the standards of the company. So as an HR, you should have proof, no? As part of your document or evidence that such employee undergone an orientation and all the standards required by the employer is already discussed to him or her. Okay, so probably you will have an acknowledgement form or attendance sheet wherein all those topics are discussed. So that is again part of your documentary evidence that the employee was made aware of the reasonable standards. Probationary employee is once terminated, probationary employee is not entitled to salaries for the unexpired term. Okay? So if probationary employee is terminated before the stipulated period, the employee is not entitled to his salaries for the unexpired term. So in other words, it doesn't necessary that you need to finish the 6-month probationary contract or employment, as long as within that or even before the expiration, if the probationary employee committed a grave violation, for example, that probationary employee committed theft or stole a company property, and after due process, then the management decided to terminate the employee, then that employee the probationary can be terminated even the probationary contract is still even it doesn't reach the 6 months probationary. Okay, like for example, if the probationary committed on the 2nd month that grave violation, then on the 2nd month after due process, that probationary employment can be terminated for a valid cause, and of course in compliance with the procedural due process. And salaries for the unexpired term, so if the probationary was terminated on the second month, so the third, fourth, fifth, and sixth months, that probationary employee is not entitled to receive the salaries for those unexpired term. Now, here's the procedure for terminating a probationary employee. Now, if a probationary employee is terminated for just cause, the following should be complied with. First is a written notice specifying the offense committed must be served upon the employee, giving him reasonable period, at least 5 days, within which to explain his side. Now, just cause example, commission of serious offense or serious violation like stealing, for example. So before you can terminate an employee or probationary employee, a notice should be given to the employee. So we call it notice to explain memorandum. And the employee should be given reasonable period of at least 5 days, and it should be stated on that particular notice. It should be included, written there, as well as the offense or omission which the employee possibly committed. So 5 days is the minimum standard or provided by law to give reasonable opportunity for the employee to explain. So that's the standard, 5 days. It should not be less than 5 days, at least 5 days, that's the minimum. If necessary, a hearing may be conducted to give employee further opportunity to present additional evidence with the assistance of counsel if he so desires. Okay? Now, example, if the employee in her or his answer on the notice to explain, he or she admitted that he committed the offense. So there is an admittance. Now, my question there is a hearing necessary? Actually, you have option. A hearing may not be conducted because there's already an admittance, but again, you can still schedule a hearing, even there's an admittance, to give, of course, to give an further opportunity for the employee to explain his or her side or present evidence. However, again, if there's admittance, it's already expected that there will be no further evidence. Okay? Now, example, if the employee did not admit in his or her written explanation, then a hearing should be scheduled, and you will have option. The employee may bring his counsel during the hearing. So in your notice of hearing, so it should be written there, the provision that you may or the employee is entitled for a counsel. Okay? Now, during the hearing, minutes should be taken. And in case you need to record the hearing, you should ask for the consent of all present in the administrative hearing. Okay? So, the consent should be recorded also. So before you can start recording and then tell the participants, especially the employee being heard, and ask for his consent that all the duration of the hearing will be recorded for purposes of minutes taking. Okay? And attendance should be taken. So there should be a written attendance. Then third is a written notice of termination must be served upon the employee, indicating the findings and conclusions that justify his termination. So after hearing, then once a decision is being made, then there should be a written notice of termination wherein it shall be served upon the employee, and there should be the findings and conclusions that would again justify the employee's termination. Okay, so we call this the twin notice rule. Twin notice because first there's a notice to explain and notice of termination. Okay. Now, second, if the ground for termination is failure to meet the standards for regularization, a written notice must be served upon the employee within a reasonable time from the effective date of termination. So, in other words, the first written notice is not necessary as provided in the first ground. But in cases the probationary employee will be terminated because of his failure to comply the standards for regularization, like for example, if the employee fails in his or her evaluation, then what is only required is a written notice served to the employee within a reasonable time from the effective date of termination. So please give time, at least a month or 5 days before the expiration of the probationary contract when you serve the termination of employment. Okay? So do not serve the probationary termination of employment on the day the probationary contract expires. Okay? So it is not safe. Okay, so that ends our topic for today. And then again, if you have question, please PM me at our Facebook Messenger or group chat, and I will summarize all those questions and answer it the following Monday, or yeah, following Monday, or if Monday is a holiday, then the next class schedule. Okay, so I hope you learned something for today and have a nice day.